Title 7, Stocks and Stockholders, Section 60, Subscription Contract. Any contract for the acquisition of unissued stock in an existing corporation or a corporation still to be formed shall be deemed a subscription within the meaning of this title, notwithstanding the fact that the parties refer to it as a purchase or some other contract. Section 61, Pre-incorporation Subscription. A subscription for shares of stock of a corporation still to be formed shall be irrevocable for a period of at least 6 months from the date of subscription, unless all of the other subscribers consent to the revocation, or unless the incorporation of said corporation fails to materialize within said period, or within a longer period, as may be stipulated in the contract of subscription, provided that no pre-incorporation subscription may be revoked after the submission of the Articles of Incorporation to the Securities and Exchange Commission. Section 62, Consideration for Stocks. Stock shall not be issued for a consideration less than the par value or issue price thereof. Consideration for the issuance of stock may be any or a combination of any two or more of the following. 1. Actual cash paid to the corporation. 2. Property, tangible or intangible, actually received by the corporation and necessary or convenient for its use and lawful purposes at a fair valuation equal to the par or issued value of the stock issued. 3. Labor performed for or services actually rendered to the corporation. 4. Previously incurred indebtedness of the corporation. 5. Amounts transferred from unrestricted retained earnings to stated capital. And 6. Outstanding shares exchanged for stocks in the event of reclassification or conversion. Where the consideration is other than actual cash or consists of intangible property such as patents of copyrights, the valuation thereof shall initially be determined by the incorporators or the board of directors, subject to the approval of the Securities and Exchange Commission. Shares of stock shall not be issued in exchange for promissory notes or future service. The same considerations provided for in this section, insofar as they may be applicable, may be used for the issuance of bonds by the corporation. The issued price of no par value shares may be fixed in the Articles of Incorporation or by the Board of Directors pursuant to authority conferred upon it by the Articles of Incorporation or the bylaws, or in the absence thereof by the stockholders representing at least a majority of the outstanding capital stock at a meeting duly called for the purpose. Section 63, Certificate of Stock and Transfer of Shares. The capital stock of stock corporation shall be divided into shares, for which certificates signed by the President or Vice President, countersigned by the Secretary or Assistant Secretary, and sealed with the seal of the corporation shall be issued in accordance with the bylaws. Shares of stock so issued are personal property and may be transferred by delivery of the certificate or certificates endorsed by the owner or his attorney in fact, or other person legally authorized to make the transfer. No transfer, however, shall be valid except as between the parties until the transfer is recorded in the books of the corporation showing the names of the parties to the transaction, the date of the transfer, the number of the certificate or certificates, and the number of shares transferred. No shares of stock against which the corporation holds any unpaid claim shall be transferable in the books of the corporation. Section 64. Issuance of stock certificates. No certificate of stock shall be issued to a subscriber until the full amount of his subscription, together with interest and expenses in case of delinquent shares, if any, has been paid. Section 65. Liability of directors for watered stocks. Any director or officer of a corporation consenting to the issuance of stock for a consideration less than its par value or issued value, or for a consideration in any form other than cash, valued in excess of its fair value, or who, having knowledge thereof, does not forthwith express his objection in writing and file the same with the corporate secretary, shall be solidarily liable with the stockholder concerned, to the corporation and its creditors, for the difference between the fair value received at the time of issuance of the stock and the par or issued value of the same. Section 66. Interest on unpaid subscriptions. Subscribers for stock shall pay to the corporation interest on all unpaid subscriptions from the date of subscription, if so required by, and at the rate of interest fixed in the bylaws. If no rate of interest is fixed in the bylaws, such rate shall be deemed to be the legal rate. Section 67. Payment of balance of subscription. Subject to the provisions of the contract of subscription, the board of directors of any stock corporation may at any time declare due and payable to the corporation unpaid subscriptions to the capital stock, and may collect the same or such percentage thereof in either case with accrued interest, if any, as it may deem necessary. Payment of any unpaid subscription or any percentage thereof, together with the interest accrued, if any, shall be made on the date specified in the contract of subscription, or on the date stated in the call made by the board. Failure to pay on such date shall render the entire balance due and payable, and shall make the stockholder liable for interest at the legal rate on such balance, unless a different rate of interest is provided in the bylaws, computed from such date until full payment. If within 30 days from the said date no payment is made, all stocks covered by said subscription shall thereupon become delinquent, and shall be subject to sale as hereinafter provided, unless the board of directors orders otherwise. Section 68. Delinquency sale. The board of directors may, by resolution, order the sale of delinquent stock, and shall specifically state the amount due on each subscription plus all accrued interest, and the date, time, and place of the sale, which shall not be less than 30 days nor more than 60 days from the date the stocks became delinquent. Notice of said sale with a copy of the resolution shall be sent to every delinquent stockholder either personally or by registered mail. The same shall furthermore be published once a week for 2 consecutive weeks in a newspaper of general circulation in the province or city where the principal office of the corporation is located. Unless the delinquent stockholder pays to the corporation on or before the date specified for the sale of the delinquent stock, the balance due on his subscription plus accrued interest, costs of advertisement, and expenses of sale, or unless the board of directors otherwise orders, said delinquent stock shall be sold at public auction to such bidder who shall offer to pay the full amount of the balance on the subscription, together with accrued interests, costs of advertisement, and expenses of sale for the smallest number of shares or fraction of a share. The stock so purchased shall be transferred to such purchaser in the books of the corporation, and a certificate for such stock shall be issued in his favor. The remaining shares, if any, shall be credited in favor of the delinquent stockholder, who shall likewise be entitled to the issuance of a certificate of stock covering such shares. Should there be no bidder at the public auction who offers to pay the full amount of the balance on the subscription, together with the accrued interests, costs of advertisement, and expenses of sale for the smallest number of shares or fraction of a share, the corporation may, subject to the provisions of this code, bid for the same, and the total amount due shall be credited as paid in full in the books of the corporation. Title to all the shares of stock covered by the subscription shall be vested in the corporation as treasury shares, and may be disposed of by said corporation in accordance with the provisions of this code. Section 69. When sale may be questioned. No action to recover delinquent stock sold can be sustained upon the ground of irregularity or defect in the notice of sale or in the sale itself of the delinquent stock, unless the party seeking to maintain such action first pays or tenders to the party holding the stock the sum for which the same was sold, with interest from the date of the sale at the legal rate. And no such action shall be maintained unless it was commenced by the filing of a complaint within 6 months from the date of the sale. Section 70. Court action to recover unpaid subscription. Nothing in this code shall prevent the corporation from collecting by action in a court of proper jurisdiction the amount due on any unpaid subscription with accrued interest, costs, and expenses. Section 71. Effect of delinquency. No delinquent stock shall be voted for or be entitled to vote or to representation at any stockholders' meeting, nor shall the holder thereof be entitled to any of the rights of a stockholder except the right to dividends in accordance with the provisions of this code, until and unless he pays the amount due on his subscription with accrued interest and the costs and expenses of advertisement, if any. Section 72. Rights of unpaid shares. Holders of subscribed shares not fully paid, which are not delinquent, shall have all the rights of a stockholder. Section 73. lost or destroyed certificates, the following procedure shall be followed for the issuance by a corporation of new certificates of stock in lieu of those which have been lost, stolen, or destroyed. 1. The registered owner of a certificate of stock in a corporation or his legal representative shall file with the corporation an affidavit in triplicate, setting forth, if possible, the circumstances as to how the certificate was lost, stolen, or destroyed. The number of shares represented by such certificate, the serial number of the certificate, and the name of the corporation which issued the same. He shall also submit such other information and evidence which he may deem necessary. 2. After verifying the affidavit and other information and evidence with the books of the corporation, said corporation shall publish a notice in a newspaper of general circulation, published in the place where the corporation has its principal office once a week for 3 consecutive weeks at the expense of the registered owner of the certificate of stock which has been lost, stolen, or destroyed. The notice shall state the name of said corporation, the name of the registered owner, and the serial number of said certificate, and the number of shares represented by such certificate, and that after the expiration of 1 year from the date of the last publication, if no contest has been presented to said corporation regarding said certificate of stock, the right to make such contest shall be barred, and said corporation shall cancel in its books the certificate of stock which has been lost, stolen, or destroyed, and issue in lieu thereof new certificate of stock, unless the registered owner files a bond or other security in lieu thereof as may be required, effective for a period of 1 year, for such amount and in such form, with such sureties as may be satisfactory to the board of directors, in which case a new certificate may be issued even before the expiration of the 1-year period provided herein. Provided that if a contest has been presented to said corporation, or if an action is pending in court regarding the ownership of said certificate of stock which has been lost, stolen, or destroyed, the issuance of the new certificate of stock in lieu thereof shall be suspended until the final decision by the court regarding the ownership of said certificate of stock which has been lost, stolen, or destroyed. Except in case of fraud, bad faith, or negligence on the part of the corporation and its officers, no action may be brought against any corporation which shall have issued certificate of stock in lieu of those lost, stolen, or destroyed pursuant to the procedure above described.